Hey, welcome to this video on question and answers on labor relations or labor 2. And the questions in this video were taken from bar Qs and questions that were commonly asked in classes. And as we start, this YouTube video, by the way, is intended for educational purposes only and not a substitute for legal advice. This may contain corrections and therefore this is only for educational purposes. If you have any legal concerns, please consult a lawyer. So let's start. First, we start with the state policy in relation to labor because this defines the framework of the policies under labor law. So we have policies such as the state shall afford protection for labor, full employment, and then we also have insurance for equal or equality in work opportunities, regardless of sex, race, or creed. So this is non-discrimination, as well as regulation of the relationships between workers and employers. Why? Because labor is imbued with public interest, and therefore the relationship, especially labor relations, which is the enforcement of the minimum terms and conditions of labor standards of employment, is governed by or is of the interest of the state. Therefore, labor relations is a primary priority is a priority of the state, and not just the state policy, but even the biblical. So, not just the state, but even the biblical policy or God's policy is even reflective of this principle. God said in Deuteronomy 24, "Do not take advantage of laborers, even if they are an Israelite or those that are from your country or foreigners." So don't take advantage of foreigners who are poor, who are, let's say, refugees in your country. Pay them their wages. Don't withhold good to them that are deserving. And God is even more specific here, before sunset. So they have daily wages because they are counting on it. Without such wages, they cannot eat, their families cannot survive. Otherwise, they may cry to the Lord and there is guilt. So even both state and the divine being requires employers or the society to protect. Okay, again, the state policy is to protect labor because it is a precious thing to protect. So let's start. So that's the policy. Now let's go to the NLRC, Title 2 of the Labor Code. Question: Who has the power to enforce compliance with labor laws? The answer is the Department of Labor Regional Director. This is from Cirineo Bowling Plaza versus Sensing. It has it is the exemption. No, his power is the exemption to the labor arbiter's jurisdiction. His visitorial and enforcement powers, this DOLE regional director, cannot be overpowered by the labor arbiter. He has the power to order and enforce compliance with labor standard laws. This also includes the determination of the existence of employer-employee relationships. And this is the next question. Who can determine? The answer is still the same. It's the DOLE regional director under his visitorial and enforcement powers vested upon him by Article 128. He may conduct inspections to make prima facie determination on the existence of an employer-employee relationships. And this cannot be overruled by the labor arbiter's jurisdiction to hear and decide big claim cases, okay, those that exceed 5,000 pesos. So his visitorial power has primacy. This is under Allied Investigation versus Secretary of Labor. What cases fall under the jurisdiction of a labor arbiter? So this is now very important because this is often asked. So you start with the unfair labor practices, and then termination disputes or illegal termination or cases for illegal dismissal. So it's adjudicatory. So the employee now comes before like a court. Before it is called, the NLRC is the labor court. Okay, so he comes before the labor arbiter for adjudication of his case. Wage cases with claim of reinstatement. Okay, because there arises employer-employee relationship and there's restoration reinstatement. Therefore, he should come before the LA or the labor arbiter. Claims for damages arising from the employer-employee relationship. So the common bond among these are there's existence of employer-employee relationships, questions on the legality of strikes, OFW claims, and enforcement of compromise agreements. Okay, again, this is the common denominator, employer-employee relationship. Therefore, those that do not have it, such as corporate disputes, cooperatives, and self-employed, are not included in the jurisdiction of the labor arbiter. So please remember that. In proceedings, next question, in proceedings before the BLR and labor arbiters, the strict adherence to the rules of court is relaxed. How does this align to the principle of due process? So we relax the rules of court, but how can there still be due process? The answer is found in Ang Tibay versus CIR. The keyword there is there should be a modicum of admissibility wherein the cardinal primary rights of the parties must still be respected. So how can there still be due process? First, there must be hearing, and then there must be evidence presented, and then there must be substantial evidence to become the basis of the ruling, and that the judgment of the labor arbiter or these quasi-judicial or administrative bodies must be independent and not just by reliance on the inferior body or subordinate body. Okay, so that's the modicum of admissibility. Does the labor arbiter have jurisdiction over corporate disputes? Na-answer na natin kanina, no, because only those that have EE relationships are under the jurisdiction of the labor arbiter. From the word itself, labor. Okay, there must be EE relationship, and of course we had learned from Labor 1 the fourfold test. Okay, who has jurisdiction over corporate disputes? It's the regular courts. Okay. So what are corporate disputes? The answer is these are disputes arising from the enforcement of the corporation code or those that arise from the internal regulatory rules or intra-corporate. So tandaan lang natin, if it's a corporate dispute, it must come from the interpretation, enforcement of corporation code and or the rules or the law of the parties or the corporation itself, which is its constitution and bylaws. How to determine if an issue is an intra-corporate controversy? So there are two tests or two elements. First is the relationship test as provided by the jurisprudence and by the law. There must be disputes between these exclusive list or these parties such as the corporations and their stockholders, that they are not employer-employees. Okay, they don't have EE relationship. A corporation and a corporate officer they don't have the employer or employment relationship. They have these stock ownerships. Okay, nature of controversy test, again, it must arise from corporation code or the constitution and bylaws. Okay, what is the nature of proceedings before the labor arbiter? The keyword here is non-litigious. The LA is not bound by the rules of court, but again, it must have modicum of admissibility, which was laid down by the court, or the guidelines were given under the Ang Tibay versus CIR. Labor arbiter versus voluntary arbitrator. What does the court say? The law gives primacy to voluntary arbitration. So the law prefers voluntary arbitration, that even a case is already under or lodged under the labor arbiter, it may still be referred to the voluntary arbitrator. Okay, even though there is this exclusive jurisdiction of the labor arbiter. So remember a while ago, there's ULP, there's legal dismissal cases. Okay, there's other things that were mentioned there. Enforcement of the compromise agreement. It can still be lodged with the voluntary arbitrator. What is the venue of the labor arbiter cases? The venue will be the residence of the place of the where the employee is regularly assigned at the time the cause of action arose. In other words, it's the workplace of the complainant. Okay, not the residence, sorry. Not the residence, but the workplace or the place where the employee was regularly assigned when the cause of action arose. So when can non-lawyers appear before the NLRC or LA? So there are three instances. First, if the non-lawyer represents himself. Number two, represents the organization. Okay, or under the law student practice rule 1383. What are the requisites of perfection of appeal from the labor arbiter? So how can you appeal and how can that be perfected? So there are three categories. As to the time, it must be filed within the reglementary period or 10 days upon receipt of the decision of the LA. Okay? And then form, there must be a form of memorandum of appeal, a memo, a document, where it will state the arguments that you relied upon, your prayer, the date and receipt of the appeal decision. So you pray to the appellate body. Now, you will attach there these attachments. You pay you pay the appeal fee, you pay the legal research fee, and that is required by law. You also pay the appeal bond. And in St. Martin's case, this must also be posted within the 10-day appeal period. And then proof of service to the other parties. So what is the landmark ruling of St. Martin's Funeral Home? This is often asked because this is a landmark case. That case, that modified the rules, okay, that from the NLRC, there's a judicial review of decisions of the NLRC, and you are seeking for an appellate court's decision, you will file under the Rule 65, but you must file it before the CA and not directly with the Supreme Court, following the principle of hierarchy of courts. So that's the gist of the landmark ruling in St. Martin's Funeral Home. Let's go now to the Bureau of Labor Relations. What kind of cases fall under the Bureau of Labor Relations? There are three categories: union matters, CBA, registry, and labor education. So first is disputes, okay, inter and intra-union disputes. Okay, if it's an or intra-union dispute, don't go to the labor arbiter, you go to the BLR, and then it stores, or it is storage, or what you call it, archives, or it is a repository of the collective bargaining agreement. And its duty is to educate employees on the rules and laws on labor. Okay. So let's go now to labor organizations. Bar 2003 question: when does a labor organization acquire legal personality? What shall be the effect then? The answer is upon the receipt or on the date that the certificate of registration is issued, or the date that appears therein. For local chapters, upon the issuance of charter certificate. Okay, charter certificate. An unregistered labor organization does not mean illegitimate. It only means that it has no legal right to demand certain rights and privileges rendered to or given to legitimate labor organizations, such as certification election and a demand for collective bargaining. Next question: what are the requirements of registration of a labor organization? So there are at least 3 common and 3 conditional. So for common, people, paper, and fee. So for the people, the names and addresses and the address of the labor organization. For the paper, 4 copies of Constitution and bylaws, and the fee is 50 pesos registration fee. For conditional, for independent union, it must comprise at least 20% of the collective bargaining unit that it represents. We will know later what's a CBU. If it exists for 1 year or more, then the financial statements or annual financial reports. And if it's a national union, at least proof of affiliation of 10 local chapters. Okay? How can a local chapter of a national union or federation be created? Again, by the issuance of a charter certificate by the national union or federation. This is a question in our quiz. What are the grounds for cancellation of union registration? There are 3. You just categorize it into falsity in the constitution and bylaws, okay? Because without the constitution and bylaws, there would be no valid union because that's where they operate or how they operate, okay? Falsity in the election of officers, or there's fraud, or voluntary dissolution by the members. So the last one is by the voluntary action of its members, and only the members can do it. For the first 2, it can be petitioned by other than the members. How can a legitimate labor organization dissolve itself? By the vote of at least 2/3 of its general membership, and the application must be submitted to the board as attested by the president. Bar 2015 question, what is the equity of the incumbent? The keyword there, since it's incumbent, meaning existing, and that applies to national. The existing national unions have the right to continue maintaining their affiliates regardless of the location of the affiliates. So let's say we have at least 10. So even if they are spread or change their industry or change their location, as long as you are an existing national union, you continue to maintain your existing affiliates regardless of the changes therein. What items can be validly collected by the union? So we have the membership fees, the union dues, assessments, the fines, and other fees for union, strikes, hospital benefits, and welfare fund. Okay? Medyo similar yung membership and union dues. Okay? Assessments and fines. Assessments are special assessments, those that are outside the regular membership fees. We will know later more about it. Fines could be like because of the fault of the union member. What is an agency fee? An agency fee are those that are charged to non-union members who benefited from the CBA. So walang libreng sakay, walang hitchhikers, okay? The union may collect agency fees from such non-union members without authorization. So it can be checked off. The legal basis for this is quasi-contract. Quasi-contract means that no person shall benefit from unjust enrichment, okay? When is a check-off of a special assessment valid? So there are 3 categories. First, majority consent, authorization by written resolution of the majority of all members in a general membership meeting. So in other words, all the members must consent. And then it must be recorded, because if it's not recorded, then it does not exist, by the secretary. And then individually, it must be authorized by the employee or signed by the employee concerned. So all must consent. The individual must consent, and it must be recorded, the minutes, okay? So when should members elect their union officers? Every 5 years. What are the rights of legitimate labor organizations? So it has different rights, and that includes to represent, to be certified as the sole exclusive bargaining agent, to be furnished with the audited financial statements of the employer. Again, that is a right, and that is to own a property as well, to sue and be sued, okay? To perform a valid strike after requirements are met, okay, if it's a union, okay? Coverage. Who has the right to form labor organizations of their own choosing for purposes of collective bargaining? So the answer is all that are employed. Only those that are employed both in non-profit and profit organizations can form for purposes of collective bargaining. In other words, only the employed. For those that are not employed, we will know later. Bar 2012 question, who has the right to form labor organizations for purposes of mutual aid and protection? So this one is the opposite. All self-employed, itinerant, intermittent, ambulant, rural workers, self-employed, and without definite employers. Okay, intermittent, this was asked in BAR 2012. What kind of government employees have the right to collective bargaining? Those that have been formed under the corporation code. But those that are formed or those that have original charter, they are they can form associations for purposes not contrary to law, such as, for example, if they have a regional charter, they cannot strike, okay, because that's under the law. Again, going back to the Constitution provides the right to strike, but the Constitution still says that it is subject to the provisions of the law. Okay, what is prohibited of managerial employees? Managers are prohibited to join, assist, or form labor organizations. The reason for this is that they have the power to lay down the management prerogatives, or the employers orders, such as to lay down, to hire, to fire, to discipline employees. Okay, to fire, of course, under just causes and authorized causes. How about supervisory employees? Those that have the power to recommend managerial actions, and then they can exercise independent judgment. Okay, and their tasks are not routinary. They are prohibited to join not the labor organizations themselves, but only they are prohibited to join collective bargaining union of the rank and file employees. They, however, can form their own collective bargaining units. What if an outside employee is included in a CBU? For example, a supervisory employee was included in the rank and file. It is not a ground for cancellation, but they are deemed removed only. ULP. What are the unfair labor practices by employers? So we have, I think we have 10. Okay, wrong number, yeah, lang yung last. So interference, yellow dog contract, contracting out, company unionism, discrimination for or against union membership, discrimination because of testimony, violation of duty to bargain, okay, or bargaining in bad faith, paid negotiation, violation of CBA, or gross violation of CBA, and union busting. Okay, for discrimination, there's a case that the employer granted benefits to non-union members. It was questioned for being discriminatory, but the court held that they are not equally or similarly situated. Therefore, there was no discrimination. Okay, because those that are union members enjoy the benefits of the CBA, while the non-union members do not enjoy the CBA. Therefore, it's just reasonable for the employer to grant benefits to the non-union members. For the CBA, let's go to what is the successor employer doctrine. It simply means that when a new employer takes over or succeeds a business in which majority of its employees are a substantial and representative complement of the former employees, the new employer must honor the employee security of tenure and the existing CBA. In other words, if an employer succeeds and the employees are substantially the same, the employer must honor the agreements. What is substitutionary doctrine? Employees cannot revoke the existing CBA by simply changing their bargaining agent, even during the existence of a CBA executed between the employer and the employees through bargaining agent. In other words, you cannot escape from your obligations just by simply, as this is for the employee side, employees cannot escape their obligations or the terms under their, or they cannot improve their terms with their employers just by merely changing their bargaining agent. Okay. What are the different methods of selecting the union that will bargain with the employer? So we have 3: certification election, that is with the order of the DOLE because it's certified. Okay, consent election, that is consented by the parties, and voluntary recognition is recognized by the employer or by the employer's decision. So what will the mechanics of collective bargaining for collective bargaining to be set in motion? In other words, in other questions, it's asked like jurisdictional preconditions. So the answer is Kyokloy versus NLRC, possession of majority status as the sole exclusive bargaining agent, and then there must be proof that it is a majority representation, and there must be a demand to the employer. Okay, this is the requisites for the collective bargaining to begin. The employer will not do the first move. It should always be the union. And the union or the employer is only legally obliged to talk to the SEBA. Other than SEBA, it is not legally required. Okay? What is zipper clause? Zipper clause is that those that are not deemed included in the CBA are not deemed raised. So once it's closed, anything that is not included there must be closed as well. Okay? What is the freedom period? It is the 60-day period before the 5-year period ends or when the CBA expires. During this time, labor unions or employers have the option to terminate or amend the existing CBA. Okay, there's also an economic and there's also political aspect of that. For strikes and lockouts, what is a strike? We have their temporary stoppage of work by concerted actions for the purpose of or arising from a labor dispute. And then we can also add here for the purpose of convincing an employer to conduct a certain action or to end the deadlock. Okay, because there are 3 grounds for a valid strike. It could be deadlock, a ULP, or union busting. So only these 3 grounds. So you perform a strike. A strike can be valid if there's a deadlock, meaning the negotiations has forestalled. Okay, there's an impasse. No more. The offer is here. The other party only extends the offer here. So there's no meeting of minds. So there's a deadlock. So what are the requisites of strike? There must be an employer-employee relationship. It must be done through concerted actions, temporary stoppage, and persuading. So this is the keyword, persuading with the working men's demands, especially when there's deadlock or if there's union busting. So you stop the union busting, stop terminating the union leaders, or stop performing the unfair labor practices. But we will also find later the requisites of a valid strike, especially the procedural one. What is a wildcat strike? This is a strike that is done without authorization from the leader. So wildcat, or no majority vote from the members. Whipsaw strike is being done one at a time against one or more employers. Sympathetic strike is done by laborers in support of other workers of different employer. This is invalid because a labor strike must only arise from a labor dispute. So since they don't have labor dispute with their employer, it's invalid. What are the requisites of a lawful strike? Actually, the complete question should be the procedural requisites. So first, as we have stated, valid ground, and then notice of strike. This is you file it with the DOLE by the SEBA or sole exclusive bargaining agent. And the notice of strike, after that, there must be cooling period. It must be 30 days if it's a bargaining deadlock, 15 days if it's a ULP, 0 days if union busting. After that, conduct a strike vote. You notify the NCMB 24 hours before the voting so that the NCMB can determine whether they have to attend or not. Once the strike vote, if majority wins, it must be reported to the NCMB. Okay? And whether of the 3 grounds, whatever the 3 grounds is, it must observe the mandatory 7-day strike ban, because this will be the time that the government or the NCMB will determine if there's coercion, okay, or if the vote is valid. After the 7-day strike ban, the strike can be staged, but only within lawful bounds, such as there must be no violence. Otherwise, they can be terminated. What is union busting? Union busting are acts that the union officers are being dismissed in violation of the right to unionize and to self-organization. Actions that threatens the life of a union. The reason why there's 0 cooling off period, because the life of the union is already threatened. So without the officers, without the leaders, they can no longer negotiate or bargain with the employer. So no zero cooling off, but still the 7-day strike ban must be observed. Let's go to termination. Termination is important. To understand termination, always understand the terms of the employees and the types of employees. For regular employees, they are performing necessary and desirable services in relation to the usual business of the employer, or those that have rendered continuous or broken service for at least 1 year, or those that were allowed to work under the probationary period. The exception is fixed-term employees. A fixed-term employee can be more than 1 year, and it's valid only on 2 grounds. First, it must be entered voluntarily by the employee and the employer. So the employee must acknowledge and knew it from the time of the undertaking. And second, he must be on more or less equal footing with the employer. It must not be like there's a wide gap between the two and he was taken advantage of. So that must be the case, okay, for fixed term. When does a private school teacher become a regular employee? In Manual of Regulations for Private Schools, it's not the labor code that determines. It is the Manual of Regulations for Private Schools that determines the regularization of the teachers. Okay, there are 3 elements. First, that the private school teacher must be working full time and 3 consecutive years. In one case, she rendered 3 years but not consecutive. So it must be consecutive 3 years, and the service must be satisfactory. When can fixed term or 5-month contractuals be valid? So this is popular independent contractors. Okay, we apply the Brent doctrine, and as what we have said a while ago, this is the exception to the regularization rule. So even if you exceed 1 year, you can still be not a regular if the Brent doctrine was observed, or Brent versus Zamora. Again, what is Brent doctrine? The contract was entered voluntarily and the employee was more or less with equal footing with the employer, with no moral dominance, no substantive moral dominance. What are the rights of probationary employees? Okay, they are, number 1, right against unjust and unauthorized termination, but there's an added one here, that their termination must be on the basis of failure to meet the clear and reasonable standards. If the standards were not clear, let's say if it's too general, that's invalid. So let's say to do the best of what he can for the company. So that's not clear. And not just clear, but reasonable standards. It must be communicated at the time of the engagement. So he cannot be dismissed even below 6 months. Okay, again, probationary employees not exceeding 6 months. Once it exceeds 6 months, they become regular. But they can be terminated before 6 months if the standards were clear and communicated and reasonable. Robinsons versus Ranches. Who has the burden to prove dismissal and abandonment? For dismissal, it is the burden of the employee. Okay? For the abandonment, it's the burden of the employer. The employer cannot say that the employee has abandoned just because he became absent. Okay, we will know later the 2 requisites. So what is the ruling in MZR versus Colambot? That the ruling is the fact of the dismissal is the burden of the employee, but the fact of the dismissal was valid is the burden of the employer. So before the employer has the burden to prove the validity of the dismissal, the employee must prove that the dismissal has existed in the first place. Why? Because this has been abused. Okay? People or employees often abuse this notion that once they file an illegal dismissal, the law will favor them or the court will favor them. They abandon their work, they failed, they neglected their duties, and they will just go to the labor arbiter and file a case of illegal dismissal. No, this is not the case. In Arkman Food versus NRC, the court said that there's over-reliance. First, the employee must prove that he is indeed dismissed. How can that be overruled? If the employer has issued letters, come back, okay, come back, report to work, etc., etc. Requisites of abandonment, again, who has the burden to prove abandonment? It's the employer. The dismissal, employee. For the abandonment, what are the two requisites? Intent and absence from work. Overt acts. Okay, overt acts or unjustifiable absence from work. Clear intent is also an element, and it is, although it's invisible, we cannot see intent, but we can see intent through actions, overt acts. Okay, to sever the relationship. What are the grounds to terminate an employee? Just and authorized causes. What are the just causes? Serious misconduct or willful disobedience to lawful orders, habitual neglect, fraud or willful breach of the trust, commission of a crime against a person of employer or his immediate family, other analogous causes. So this is always the point of contention or cases. Is that a serious violation? Is that a serious misconduct? Is that a willful disobedience? Another one is authorized causes. Labor-saving devices, redundancy, retrenchment, business closure, and decease of employee. For labor termination, teacher fell in love and married her grade 6 student 14 years apart. Is that serious misconduct? And is the dismissal valid? In Chuakwa versus Clave, no. Deviation from societal norms doesn't always equate to immorality. The school failed to show sufficient basis of the definition of immorality. Absent such specific policy, there can be no grounds for serious misconduct. Okay. Also, pregnancy or premarital pregnancy of an HR officer in a hospital and college. The court said that this is not serious misconduct and this is not immorality, because the law or immorality must be construed as to how the law defines it, not on religious views. It is defined by public and secular standards, and the court in one case said how respectable people view it as immoral or scandalous. If it's not viewed as scandalous by respected people of the society, then that's not immoral, unless there's a specific ground or policy stating such action to be a ground for termination. When can disobedience be a valid just cause for dismissal? Okay, for disobedience, it's not merely like willful, it must be perverse and wrongful. For an order to be a valid basis, it must be made known, it must be reasonable, and in connection with the duties or relevant to the business industry of the employer. When may a compromise settlement or quitclaims be valid? First, it must be voluntary entered upon, not contrary to law, not unconscionable, and it must be reduced in writing. So we have here the consent, the legality, reasonability, and the form. It must be in writing in the presence of the DOLE or BLR. Redundancy versus retrenchment, what is the difference? There are many, but the main ones, the hallmark distinction is that redundancy must be exercised in good faith, and retrenchment also must have substantive or valid causes. Okay, for redundancy, the cause is excess supply of workers. For retrenchment is economic grounds. The purpose for redundancy is to meet the actual requirements, and for retrenchment to avoid business losses. Redundancy may be permanent, retrenchment may be temporary. What is the twin notice rule? For the twin notice rule, it is for just causes, and for authorized causes, they actually have the twin notice, but for just causes, you have first to notify the employee to explain, notice to explain, and then there must be hearing, and then notice of termination or notice of the decision. For authorized causes, you only have to notify the employee once, but the other notice should be sent to the DOLE, and it must be 30 days before the date of effectivity of the termination. Is the twin notice rule required for probationary employees who failed? Next, distinguish just and authorized causes. So as to the ground, just causes always rely or is always based on the irresponsible or neglectful performance of the employee, okay? While authorized causes are based on external factors such as the economic or operational situation of the employer, okay? Except the health of the employee, it can be a valid authorized cause when it poses danger to the employee or to his co-employees. For separation pay, just causes does not oblige the employer to give separation pay, except if there is balance or balancing of interests, or upon just determination the employee is entitled to separation pay for social justice purposes. For authorized causes, the law requires that the employer gives separation pay, and we will know later how much is it, depending on what ground. So for twin notice, as we've said, it is required with just causes. So there are two notices. First is notice to explain or notice to apprise the employee of the charges against him. And then there will be hearing. After that, the last notice, is the notice of decision, or it could be the notice of termination. So therefore, there must be somehow the the modicum of admissibility in just causes. For authorized causes, no need for hearing. Therefore, only for employee, only one notice. Notice that we are closing, notice that we are having retrenchment, and it could be coupled by the financial statements of the company. The other notice is not to the employee but to the government, and that is the DOLE, for the determination of the validity of the allegation of the presence of authorized cause. For hearing, it is required in just causes, not required in authorized causes. For authorized cause, here are the separation pay. For installation of labor-saving devices or redundancy, the employer is required 1 month pay or 1 month pay per year, depending on which is higher. The reason for this is that the employer is upgrading. This action would lead him to save money. So it would be painful for the humans, but it would be it would be painful for the employees but not for the employer. Therefore, the separation pay is higher. While in retrenchment or in health reasons, for health reasons of the employee, 1/2 month per year of service, or 1 month, whichever is higher. Okay, the reason for this is the employer is already suffering, therefore his obligation would be lower. The exception for this is when there is serious financial losses. So mamamatay na nga, malulugi na nga, kukunin mo pa, no? So a fraction of 6 months is deemed to be 1 year, or is calculated as 1 year. Is exogamy valid? So what is exogamy? Exogamy is you marry outside your social group. So that's the plain meaning of it. But in labor law, exogamy is to require employees, kumbaga, to marry outside the company. Okay? In other words, it is the employees are prohibited to marry each other. So this is somewhat opposite to religions, no? There are some religions who only require them to marry each other within the religion. So it could be the opposite of exogamy. Some companies have this policy because they have this notion that the company trade secrets, for example, or the company will be subject to embezzlement if there is marriage within their employees. So if you marry your co-employee, you will be deemed terminated. In one case, this is a landmark case of De La Cruz versus One Network Bank. The court held that the employer has the burden to prove by substantial evidence that the policy is reasonably necessary. There must be logical connection as to why this policy of not allowing them to marry is related to the performance of the business. For example, the employer must show that marriage between the employees will cause embezzlement of funds or will expose confidential information of the employees. Otherwise, the policy is illegal. So, the court said that there must be reasonable necessity and those who qualify on the requirements cannot properly perform the job. For example, the company must show that those employees who married each other cannot perform their job properly. So, what kind of job that will render you incapable if you marry another employee? So, that's the question that the employer must answer to justify exogamy. Okay? Next, question, what are the types of separation pay? Under the law, there are statutory separation pay, and actually this is related to these 3 and 4. 3 is alternative reinstatement of an illegally dismissed employee. This is by jurisprudence if the court rules that the employee is illegally dismissed, therefore he must be reinstated. However, if the relationship is already severed to the fact that it is no longer possible for them to reunite, then the doctrine of strained relations apply, and instead of reinstatement, the employer will just pay separation pay. So meron talaga na kahit anong gawin mo, hindi na kayo magbate, hindi na kayo magkabalikan, kahit ano pang pilit. So, bayaran mo na lang. Okay? And then, financial assistance to legally dismissed. Again, this is a measure of social justice. For example, he committed serious misconduct but he already rendered like 30 years of service, more than half his life, to the company. And then gumawa siya ng crime against the employer, for example. Or, well, maybe that's too serious. Maybe, let's say, serious misconduct or unlawful disobedience. So, willful disobedience to a lawful order. So, the separation pay would be conscionable or reasonable at this point of time. So number 2 is employment benefit. Maybe it could be required by the CBA or out of the gratuitous heart of the employer. Okay. What is preventive suspension, or when is preventive suspension valid? So again, what is preventive suspension? If it appears that the employee's continued presence will pose danger to the employer. So it could be employer's money, it could be employer's life. So these are employees that occupy positions of trust, okay, and confidence. And therefore, they must be held under a preventive suspension for a number of days while the investigation or while the case is going. So, that's it. Thank you very much. I'd like to leave this. Leviticus 19, do not defraud or rob your neighbor. Do not hold back the wages of a hired worker overnight. This is a reminder that the duty to maintain industrial peace or peace in labor law, or labor law itself is a law coming or descending from a higher order because of even the Levitical laws command such principles. Okay? Thank you very much. God bless. Bye-bye.